The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. And welcome this evening, and thank you so much for coming out on a rather difficult night, I think, for most people trying to get around. But thank you for being here. And Mr. Nelmark, thank you for helping us out this morning in introducing the case. We have one case that will be submitted this evening. That case is Jerome Aaron Mitchell and Bracken Ann Mitchell versus the City of Cedar Rapids and Officer Lucas Jones. And Mr. Stone, you may proceed with your argument.
Your Honor, may it please the court, good evening. My name is Bill Stone. I'm from Cedar Rapids, Iowa. I'm here this evening appearing on behalf of the City of Cedar Rapids and Officer Lucas Jones. With me this evening is Liz Jacoby from the City Attorney's Office and Greg Usher, who's in my law firm. The interlocutory appeal this evening involves a straightforward discovery dispute between the parties regarding a mutual protective order that's been proposed by the appellants, but it's complicated because it involves confidential public records. With all due respects to the district court, we believe that the district court abused its discretion in refusing to grant our
What makes this record confidential?
the record.
What code section says that it's per se confidential?
22.75, Your Honor.
Doesn't that require an ongoing investigation, though, to fit into that one?
Only if it's telephone billing records or emails, Your Honor. There's no requirement for the first sentence of 22.75 that there be any kind of ongoing investigation. It's an unconditional, confidential section of the Iowa Code, Chapter 227.5.
Well, it could be, but the Mediacom case has some language that I think I'd like to hear you respond to, and I'm going to paraphrase a little bit, but you'll recognize it, I'm sure. Iowa Code Chapter 22, Open Records Law, pertains to parties seeking access to government documents and ordinarily has no application to discovery of such information in litigation. So, the ACLU case that you've talked about quite a bit in the brief is an open records case, of course, but this isn't. This is a discovery case. The Mediacom, at least, says that Chapter 22 has no application in discovery. So, isn't this just a bread and butter discovery dispute, subject to the ordinary balancing test that we all are familiar with in litigation?
That's partially correct, Your Honor. Mediacom says that Chapter 22 does not trump the discovery rules, but Mediacom involved a situation where the defendant in that case absolutely refused to produce any of the documents at all, claiming a trade secret. And why this case is different, we are willing to produce all the requested records to the plaintiffs as long as they're retained as confidential in the scope of this litigation. And that's the key difference.
Well, but look, ordinarily in litigation, when you have voluminous records and so forth, the parties have an opportunity to seek protective orders, and ordinarily you identify specific documents, for example, a medical record, or maybe a personalized information, or maybe actually a police investigative report that has mental impressions contained in it. That's probably the high watermark, and there may be other kind of documents here. But ordinarily, the protective order focuses on specific documents. The burden is on, ordinarily, the person seeking protection. And that's not really what we've got here, I don't think. Tell me, push back, tell me I'm wrong, tell me how I should approach the case.
This is a discovery dispute between the parties. We have proposed a protective order, which is the same one that was approved by the district court in another officer-involved shooting case entitled Steele versus City of Burlington. And so, as we discussed with the trial court, when it came time for us to begin discovery and look at the production of possibly confidential records, we came up with this mutual protective order. And it doesn't just merely protect the records from the city and Officer Jones. It would protect the plaintiff's medical records and other confidential information that they want to use in discovery also.
Counsel, what's the harm to the city or potential harm if the records are publicized?
Well, there's several, Your Honor. First of all, these are confidential public records under 22.75, so there are obviously the public interests that involved here, that police officer investigative reports are to be retained as confidential so that the law enforcement is allowed to interview witnesses, do investigations, prepare memorandums, and investigate theories of the case.
Is there any exception to that, by the way?
No, Your Honor. In terms of 22.75? No.
I read 22.75, and the first sentence says, peace officers' investigative report, privileged records or information specified in section 80G2 and specific portions of electronic mail and telephone billing records of law enforcement agencies if that information is part of an ongoing investigation. Doesn't, if as part of an ongoing investigation, modify all those things?
No, Your Honor, and that's what the parties have briefed ad nauseum, I think, about the last preceding antecedent, which is a statutory interpretation. I would like to point out, though, there was a district court judge here in Polk County who has already interpreted 22.75 and who has interpreted the provision as requiring absolute confidentiality of the records at issue, and has similarly rejected that there's any balancing tests that should be applied as to whether or not these are truly confidential records that could be disclosed in the court's discretion. So that's one reason why we're here this evening, is because...
Is it true the investigation was closed, it was no longer ongoing?
That would be correct, Your Honor.
And no confidential informants?
There are no confidential informants in this matter.
Again, if we do apply a balancing test, what would be the actual harm to any witnesses or any I didn't see any affidavits or any evidentiary proof of the harm here. It's more argument that it would have a chilling effect in investigations generally, but can you help us out on that issue?
It's a legislative intent expressed in 22.75, Your Honor, that police officer investigative reports are supposed to be maintained as confidential, and there aren't any exceptions to that. This case should
What
be...
about the provision, the middle sentence that ends, except in those unusual, however, the date, time, specific location, and immediate facts or circumstances surrounding a crime or incident shall not be kept confidential under this section, except in those unusual circumstances where disclosure would plainly and seriously jeopardize an investigation or impose a clear and present danger to the safety of an investigation. So is that kind of a built-in balancing test?
No, it isn't, Your Honor. In fact, that's where the district court erred in his interpretation of 22.75.
If the district court erred, then doesn't that mean we also erred in Hawkeye, where we took the same language and applied a balancing test?
And I'll come back to Justice Waterman's point later regarding the difference between those first two sentences, because I would like to
Go
address
ahead and finish your answer to him first. I'm sorry.
I'm going to follow up with you then too, Judge, but Your Honor, Neer versus the state of Iowa clearly distinguishes between the first sentence of 22.75, which involves peace officer investigation reports, and the second sentence, which is called the immediate facts and circumstances test. The immediate facts and circumstances has already been disclosed to the plaintiffs here, along with thousands of public records. That's not at issue here. The issue in front of this court is whether the district court erred in ordering us to produce those peace officer investigation reports without any confidentiality order. And that's...
Well, how will their ability to prosecute their claims in court be impeded if they can't publicize the records that they will have?
By publicized, you mean with the media, Your Honor? Well, because discovery under our rules of civil procedure is effectuated by the production of documents, not their dissemination to the public. And dissemination to the public is particularly worrisome for this court in our rules and our cases because of potential pretrial publicity.
Well, there are a lot of cases that deal with that, and a lot of what I will call plain vanilla discovery cases involving allegations of police misconduct, and I've seen 30 or 40 of them at least. Most of them, they vary, but most of them favor public disclosure. At least that's my reading of it. I want to give you an opportunity to say, no, they don't, or distinguish your case. But generally speaking, in litigation of police misconduct cases, the district courts, federal district courts, most of these have favored disclosure. Do you disagree?
I disagree. Judge Gritzner in the City of Burlington case, there was an express protective order. In fact, the same one that we've proposed to the parties in this case was the one that was approved by 7 lawyers and the magistrate judge in that City of Burlington case. And likewise,
Well, but that's not, I'm sorry to interrupt you. Go ahead.
the
Go ahead.
Shanahan case from 1984, this court approved a protective order of the DCI files in an officer-involved shooting case also. So there is precedent for granting protective orders for this type of information.
But they're pretty narrow and highly focused. I mean, I suspect there's, of all the documents that are subject to discovery, as I indicated earlier, there's a high water mark. I mean, personal information, social security numbers, medical information, internal police review matters. It seemed to me, specifically, most judges would probably grant protective relief, but not, protective orders are supposed to be narrow and focused on specific items and not kind of broadly based and not putting burdens on one side or the other side.
Well, just recently, this court in Sioux Farms versus Eagle Labs talked about the prevalence of these stipulated protective orders, how they have a unilateral right
Well,
of
but we
part.
don't have a stipulated protective order here.
Admittedly, but it was a stipulated protective order in the City of Burlington case, and it could have easily been a stipulated protective order here had the parties signed. But I will just say generally that protective orders where the parties agree to them or where there's confidential trade secrets involved, like in Microsoft or any Mediacom or Farm or any of those cases, the parties are able to conduct discovery and prepare for trial with a protective order in place. And this protective order is not going to impede anybody's ability to prepare for trial and otherwise get ready in August 2020 when this case proceeds to
I have a
trial.
question for you, sir. Would you agree with me that Chapter 22.7, you're relying a lot on that to protect you, that the information you are seeking to protect is confidential? And Justice Wiggins mentioned that qualifier if that information is part of an ongoing investigation. And I understand you're arguing a statutory construction on that. But if you are wrong on that, and then if this court were to interpret that sentence to actually qualify everything before it, would you agree with me that the information being sought does not involve an ongoing investigation?
If this court decides to read that there has to be an ongoing investigation for peace officer investigation reports, then that would be correct, Your Honor. But there isn't any way that should be this court's interpretation, with all respect, because that sentence you just read to me also contains the Iowa Code Chapter 80G.2, which involves confidential informants. And there isn't any way that I believe the legislature or this court would want confidential informants information known once an investigation is no longer ongoing. By including that provision in there, it's pretty clear that there's an unconditional confidentiality associated with peace officer investigation reports.
But is that a different term? I mean, the provision begins peace officer investigation reports followed by privileged records or information specified in 80G. Isn't that a separate category from routine police investigation reports?
I think they lumped them all in there, Your Honor, because they wanted to be sure that everything that was related to the police officer's ability to investigate and use informants and follow through on tips and leads and interview witnesses had to be confidential unconditionally.
Could I ask you to get back to my question, Mr. Stone? So we did say in Hawkeye, interpreting kind of the language that's at issue here in 1994, that you apply a balancing test to it. Since then, the legislature has touched that exemption, 22.75, a couple of times and hasn't done anything to overturn that decision. but it's even while amending other language in the provision. Usually, we say that means that the legislature has acquiesced in our interpretation of 2275. Why should we do anything with our prior Hawkeye decision now?
Hawkeye involved the application of Iowa Code 622.11, which is an evidence statute which involved public officer immunity, if you will. And that evidence statute is one that applies to the courts and contains such things as statute of frauds and so forth. I'm not sure that Hawkeye really involved a balancing test of 22.75. I think the problem occurred when this court in Gabrielson, which decided that they were not going to balance the school examination reports in that case several years after Hawkeye, made a citation to the Hawkeye case that I believe was erroneous. Instead of saying that they were clarifying or reversing or were distinguishing Hawkeye, they made a citation under the Blue Book of CF, and I know this is getting highly technical, but I think it's important for this court to note. This is on page 273 of Gabrielson. The court in Gabrielson said, CF Hawkeye versus Jackson, holding language of 22.75 exception expressly requires a three-part balancing test. That isn't what the court did in Hawkeye. Hawkeye did a three-part balancing test on 622.11, and witness statements are incorporated into peace officer investigation reports. I want to also note regarding statutory interpretation. After Atlantic, the Iowa Supreme Court came in and amended 22.711, and they specifically included in there the issues that were raised, I believe, by the dissent about not knowing about the documented reasons and rationale for termination of public employees. They didn't say anything about the balancing test. They didn't change or alter any of those cases. So far, there are at least 3 cases that say that personnel tests in Atlantic, Gabrielson school examination reports, and then also the case involving autopsy reports, Symington, all have said there's no balancing test to be applied. And I think the reason for this should also be recognized by this court in your decision in Waterloo 2, which involved Iowa Code Chapter 20 and the interpretation of that section. And I want to note the specific language that was cited by this court in Waterloo 2 because I think it's relevant here. Section 20 of the Iowa Code involves collective bargaining for public employees, of course, and mandatory versus permissive topics. And this court, in a lengthy decision discussing all the other authorities and looking at NLRA law, concluded in that decision and said this: it is not surprising that the state court application of threshold balancing tests has yielded a riot of fact-specific results that defy orderly characterization. I think that's what's at issue here. I think when you're interpreting 22.7 of the Iowa Code, which is 72 exemptions that the legislature has said are confidential, that it has to be, and if as this court has said also, if they're clear and precise and they've written that with clarity, that you have to respect the legislator's intent. And unless there is a balancing test expressly stated in the statute, which there is, in the Northeast Counsel case, this court found under 22.76, the legislature knows how to write balancing language. They did so in 22.76, but it's not anywhere else in that statute.
Okay, thank you, Mr. Stone.
Thank you.
Ms. Schultes.
Good evening. May it please the court. We agree with defendants that this is a straightforward discovery dispute. We filed this case in civil litigation, we served our discovery requests, and defendants filed a motion for a sweeping protective order to keep a broad range of documents, some potentially covered by Section 22.7, some potentially not, hidden from the public.
But they'd be turned over to the plaintiffs, right? So you would be able to see them, read them, use them in the course of the lawsuit. How is the plaintiff harmed by not being able to disclose them to third parties or the media?
First of all, the question presumes that the burden is on us to show that we would be harmed. The burden, both under protective order and both under Section 22.7, is on the party resisting discovery to establish that they would be harmed by disclosure. The thrust of our discovery rules, the thrust underlying the high standards for the grant of a protective order, and the thrust of the Open Records Act is in favor of disclosure. The defense in their briefs raises the issue of the threat of this information getting out to the public. At this point in time, the information that's out in the public is that which the defendants have put there, the information that they've decided the public should know. And our interest here is in getting all of the information in front of the public, in part through the trial process.
And the dash cam video is already out there, but again, how is your case impeded by if you can't take these records and share them outside of the litigation?
First of all, as a practical matter of litigation, I think that it does increase the work that the attorneys have to do. There's additional tracking that has to be, these things may seem minor, but we certainly have to keep track of our files, which ones have to be filed under seal, which ones wouldn't have to be filed under seal, who we can talk to about this case. We have to retain them as a consultant or an expert before we can talk to them, or if we can have informal discussions with our colleagues outside of our practices in order to explore avenues of litigation and case development strategy. And then certainly the principle that, we are entitled to open discovery because it's the reality of litigation in this day and age that similar cases arise with different litigants and with different attorneys, and the courts have recognized that there's an interest in litigants in being able to share the discovery. That's particularly important in this case where there's parallel litigation happening in federal court relating to a different shooting involving a different victim, but the same officer of the Cedar Rapids Police Department. So certainly our litigation strategy would be hindered.
But doesn't the case, doesn't the dispute come down ultimately to the meaning of 22.75? Because it strikes me that if the document is not covered by an exemption, then clearly you're entitled to disseminate it. That clearly it is. If it is covered by an exemption, if it's confidential, then it strikes me you shouldn't be able to avoid that provision. You should be able to get it for litigation, but you shouldn't be able to avoid that confidentiality or that exemption from public disclosure provision simply because you happen to be a litigant. So don't we have to just decide what 22.75 means here?
I think the court can choose to go there if it wants to. I think this case could be decided on the issue of the protective order. But I also think that the two tests are harmonized when you apply the balancing test. And we haven't discussed this much yet tonight, but actually the beginning of Section 22.7 provides an escape clause. That even if there's a categorical exemption, which we don't concede in this case, that the prefatory language to all of the exemptions is that the court can otherwise order disclosure, regardless.
I think if Chapter 22 applies in this case, arguably you have an uphill battle. And you have an uphill battle because the ACLU case, I'll call it, does talk about categorical coverage of the long laundry list. But if you're in ordinary discovery dispute of a piece of litigation that we're all so familiar with, then you're on a higher ground because the particularity that's required for protective order in litigation is not the categorical judgment that Chapter 22 provides. So make me your best argument that this isn't a 22 problem. This is just a bread and butter discovery problem.
First of all, Atlantic, I'm not sure what the reason for this was, but reading the decision does not appear to have addressed the introductory language to 22.7. It's not addressed. And therefore, that was what was addressed in Hawkeye. 22.7, the introductory language, unless otherwise ordered by court, is actually italicized in Hawkeye.
Well, MediaCom case, what do you make of the MediaCom case? It says that Chapter 22 has no application.
Right. Our position is that these are two parallel paths. They're separate but parallel paths to get documents from a governmental entity. One is through the open records request, which is not why we're here today. The other is through discovery, which is why we're here today. And our argument would be that litigants in discovery actually do as the longstanding history of our courts is to open trials up to the public, to invite the public in, like we have this evening, to observe the inner workings of the court. And so when a litigant is a real party in interest, is able to bring a lawsuit, is governed by the rules of procedure, then their avenue to accessing records may be greater than that of the general public submitting a FOIA request.
What's the significance of the second phrase that was added by the 2017 amendment? You know, privileged records or information specified in Section 80G2.
The significance of that, I think, Your Honor, that tends to weigh in favor of the balancing test being applied. If you read the Hawkeye decision, the Hawkeye court is very concerned with ongoing investigations, protecting confidential informants, protecting potential witnesses from harassment or embarrassment or threats or intimidation, protecting the integrity of investigations. And in fact, one of the cases that defendants cited as support for courts not ordering records to be disclosed actually dealt with an ongoing investigation. And so I think the legislature's concern for protecting individuals who are participating in an investigation weighs in favor of applying the balancing test, and that the balancing test, if applied to these exemptions, would provide the district courts with the tools necessary to not order disclosure when the circumstances require that. But that's not what Judge Grady found in this case. He found this case was of broad public interest. None of those factors highlighted by the Hawkeye court were applicable. The investigation was closed, the grand jury proceedings were over, and the Cedar Rapids community had a vested interest in debating this issue.
Let me ask you about the ongoing investigation aspect of the statute. Mr. Stone points out in brief that in 2006, the language was added, electronic mail and telephone billing records, that information is part. The ongoing investigation language didn't come into the statute until 2006, and then it's kind of married to mail and telephone billing. Doesn't that suggest that the qualifier applies to electronic and mail matters?
It's not dispositive on the legislative intent, and I can't remember the exact words that's in our brief, but I know we addressed that in our briefs when we discussed the language that comes after that in some of the cases that talk about the interpretation with the, which modifiers apply to which clauses.
I'm not 100% sure the comma knocks it home, although those of us that are grammarians might be interested in it. But the fact that language about ongoing investigation wasn't even in the code until the electronic mail and telephone billing was introduced strikes me as a narrowing construction. And I also want you to maybe address the last sentence now, which talks about electronic mail and billing records are not confidential if the statute of limitations has expired. Makes a certain amount of sense. If the statute of limitations is gone, there's no ongoing investigation. So, but that too, the last sentence is tethered to electronic mail and billing records. So in context, the legislative history, it strikes me, tends to point against your interpretation. Help me out.
I think what that brings us to is the fact that the whole code section is ambiguous to begin with. As was clear during the first 15 minutes of argument, what constitutes a police investigative report seems to be ambiguous. It's made even more ambiguous by the ongoing investigation clause, and even more ambiguous by the exception to the exception that's carved out in the second half of section 22.75. So our position is, that given the ambiguity, given the prefatory language to 22.7, given that this is a discovery dispute and not an open records dispute, the balancing test is the appropriate test to apply here, and Judge Grady didn't abuse his discretion when he found that the balance weighed in favor of disclosure.
What do you make of the ACLU case then? I mean, it has some pretty strong language saying that there's a laundry list, and playing off Waterloo 2, there's a laundry list. The legislature establishes categories. Legislature has already done the balancing when it establishes the categories. How come we're doing a double balancing?
Well, the policy behind the Open Records Act is clear that
I want you to address the case. I'm sorry, but and tell me the case is wrong or it doesn't apply. But ACLU, it seems to me, stands for the proposition that we look at the categories of these exemptions to the Public Records Act, And we don't engage in a balancing test to see if we release them or don't release them. The central question in ACLU is, does it fit within the box of the category? And if it does fit within the box, then it's exempt from disclosure. Now, I understand the box might be kind of fuzzy at the edges, but once we put it in the box, it's there. Now, isn't that what ACLU says, and doesn't that apply in this case?
Our case is distinguishable because apparently in ACLU, the introductory language to 22.7 wasn't addressed. There's an escape valve. When fundamental rights are at issue and the underlying purpose of the exemption will not be frustrated, the courts can order disclosure. ACLU didn't even address that. Hawkeye did. Hawkeye cited a 622.11, and it cited to the prefatory language of 22.7, italicizing, when otherwise ordered by the court, said that the balancing test, that the principles underlying those two confidentiality or privilege positions are the same, and that a balancing test should be applied. And our case mirrors Hawkeye. Hawkeye took place in the context of the Rodney King riots and allegations of police misconduct here in Iowa. Our case is taking place in the context of a national debate about proper police procedures across our country. That debate landed on our doorstep in Cedar Rapids when Jeremy Mitchell was shot.
Can I ask just a practical question I'm curious about? Neither side is disputing that you have a right to the records, right? The issue is, can you disseminate them to third parties? You don't have the records yet, do you?
Subsequent to this case being taken up by the Supreme Court, there was some disclosure of records. The stay for the protective order was lifted, so that records were disclosed to us. They're all marked confidential at this point in time. No further discovery has been exchanged between the parties.
All right, so you do have some of them. Based on that, does that affect, without disclosing that, does that affect your argument in any way? I mean, is there, in a general sense, is there any general point you can make that would help us decide the case? I'm going to ask the same question of them.
There's nothing in the records that would make Hawkeye inapplicable in our analysis of those records that would suggest that any of the risks that the balancing test is inclined to address, such as informants, threats, intimidation, ongoing investigation. There's nothing in the records that would indicate that any of those factors are at play. And the defendants have not set forth any specific statements about what risks there are to the public. They've made mere conclusory statements, and that's insufficient for protective order. It's insufficient for denying an open records act.
How do you answer the defendant's arguments that if we affirm here, more generally, it will have a chilling effect on police internal investigations or the willingness of people to come forward, witnesses?
Well, I think the discovery rules and the principles underlying the Public Records Act have answered that question. The legislature has determined that it's the public policy of our state that open government is a good thing, and that people trust that which they can observe and tend to distrust that which they cannot observe. And so our position is, unless they can set forth specific facts and evidence, some empirical evidence, some examples, something, that the standard simply hasn't been met, that's actually a risk here. That the result wouldn't actually be the opposite, that there might be more truthfulness and more candor and more openness and more trustworthiness if everyone knew the public could see what was going on behind closed doors.
What would you think of an order that allowed you to use the records with witnesses and experts and in developing litigation, but said no disclosure to the media?
That would be an improvement from the proposed protective order that's currently at play. But again, our position is there's no gag order in this case. It's the longstanding policy of our judicial system that the litigation process is open to the public. Eventually the case is going to be in front of a jury, and we enter this slippery slope of, well, can we enter these things into evidence? Are we going to seal the trial? Are we going to keep the media out of the trial proceedings? Are we going to gag the jurors from being able to talk about?
You have quite a few orders like that as I looked around, and the case survey that I did, it seemed to be that there was oftentimes a significant interest in protecting the jury pool, and that is at least somewhat applicable here, is it not?
I think in every case, it's important to make sure that we have a fair and impartial jury. The district court judges across the state of Iowa are entrusted with the duty to make sure that that's going to happen. The voir dire process helps to make sure that that's going to happen. And so to the extent that that's a concern, that there are procedures and rules in place to make sure that that doesn't come to pass.
A technical timing question, your discovery requests were served before the effective date of the 2017 amendments. Do you agree that we should use the 2017 version of the code that was quoted by Chief Judge Grady rather than the 2016 version that lacks the second phrase about Section 80G?
Yes. Am I
Schultes,
over time? Yes.
you are.
Thank you, Your Honors.
Thank you very much. Mr. Stone, you present your rebuttal.
Thank you, Your Honor. Discovery occurs between the parties largely unregulated. We are not here to seek a protective order of any information presented at a jury trial. That will be a matter for the trial court to decide in his or her judgment based on admonitions to the jury about not considering outside evidence. What we're solely concerned with here is the discovery process between the parties proceeding, and our protective order does not inhibit them in any way. This is a battle-tested, commonly used protective order of both sides' information.
What are you afraid of them having the option of not making it protected? I mean, what's the harm to you?
Well, besides what we've already talked about, that these are confidential public records that are not to be disclosed, this court has also made it clear in our rules of professional responsibility and also in criminal cases and civil cases involving the issue of jury misconduct and jury intrusion and potential pretrial publicity that might arise, and particularly in jury trials.
But if the records are disclosed, these folks on the other side are bound by Rule 32:3.6 about pretrial publicity and disclosing these records and doing things. I mean, they have those ethical duties where they can't just start sending piecemeal to the newspaper and stuff like that.
Well, the rule that you cite applies to attorneys only. That it wouldn't apply to the parties themselves. And I can only state again that this particular protective order, as I stated to the trial court, this protective order was entered early on in that City of Burlington litigation.
Yeah, but the City of Burlington protective order wasn't passed on by any appellate court as to what it means under the statute. It was a stipulated order, and you entered into it. So why should we give that any weight?
My point was going to be, Your Honor, that in reviewing the PACER and reviewing the docket sheet, that particular protective order led to no discovery disputes between the parties, and in fact, it went all the way to settlement without any issues at all. And so there isn't any reason to believe that this particular protective order wouldn't work in this case also.
Mr. Stone,
not-
how is the public interest in open government ever protected when it comes to police investigative reports?
Your Honor, we believe that the public interest is reflected in Chapter 22 generally by saying that these records are all public records. But they've also made it clear that the public interest is also served by having 22.7, which has 72 express areas that are to be kept confidential by the custodians. And so the public interest is expressed in that particular provision.
Could Cedar Rapids have withheld the dash cam video if they had chosen to do so, in your view?
I'm speculating. I'm not sure what went into the decision-making, Your Honor, but as we've talked about earlier, the second sentence of 22.75, where the parties a public entity is allowed to disclose the immediate facts and circumstances, that particular dash cam video could constitute the immediate facts and circumstances.
Because you see the concern expressed by the other side that open government is one thing, and then selective open government is also something that raises a concern when the government only releases what they choose to release, what they choose the public to know. And that strikes me as maybe contrary to the philosophy of Chapter 22. Don't you agree?
I don't, Your Honor, because whether it's discovery between two litigants like us here this evening, or entities like the ACLU or any other civil rights organization that wants to obtain public records, 22.7 arguably applies to both of them, whether it's in discovery or in an open records request.
But
So-
a custodian can release in the discretion of the custodian. Your position is that the city can release favorable parts of a police investigation and withhold unfavorable parts, right?
No, because I've already stated, I believe that dash cam video, which recorded that specific facts and instances, is specifically allowed by the second sentence of
No, it could be,
22.75.
but I guess I'm speaking more broadly. You have a investigative file that contains
Right.
the hundred sub-files, some of which might be favorable to the city and some less favorable. Your view would be that the custodian could release selectively parts of the file and withhold other parts.
That's not my position. We are absolutely claiming that we were not going to release any peace officer investigative reports unless we're ordered to do so under a protective order, unless this court orders us to do it otherwise. And we are consistent with our approach on that. We don't selectively or intend to waive any confidentiality by selectively releasing some and not others. But we will certainly always follow any court order on that. Absolutely. I'd like to talk also about this comment made by the other side about this language, this escape clause language that allegedly allows you to decide when to allow certain documents to be released. And the phrase is this, unless or otherwise ordered by a court. That argument was put to bed by the Court of Appeals in the Symington case, which involved autopsy reports. And the Court of Appeals said expressly there, we do not view the unless otherwise ordered by a court language as authority for a court to order release of an otherwise confidential public record whenever it thinks that would be fair and appropriate. And then the court went on, the Court of Appeals went on and said, the General Assembly has written those 64 separate exemptions with considerable care and detail. The language is specific and clear. We are not at liberty to choose a different balancing of public interest. So that's an autopsy report. You have over 1,400 public records custodians in this state, in addition to private litigants, in addition to, and also citizens. If we are going to have a riot of fact-specific in the things that were pointed out by this court in the Waterloo 2 case, it's going to result in unacceptable results for everybody. We need a bright line test as to whether or not those 22.7 exemptions are going to be applied, that parties believe they're to be applied under 22.7. Finally, I'd like to make one last observation.
You may sum up, Mr. Stone.
Thank you very much. I want to close with Judge Gritzner's, in his decision to release those records after the case had already been settled in the City and Burlington case, recognizing that it's not binding on this court, of course. The issuance of a protective order early in this litigation was sensible in order to facilitate discovery and to ensure that any information discovered would not taint a potential jury. But the interests behind the protective order are no longer salient. The result of settlement is that there's no need for additional discovery and there's no prospective jury to be tainted. And that's all we're asking for here, is that the court ordered Judge Grady to sign the protective order that we have presented, that the parties be allowed to go engage in discovery, and if there's any issues between us, we will bring them before the district court. Thank you very much for your time this evening.
Mr. Stone, thank you as well. Ms. Schultes, thank you again. Before asking the bailiff to adjourn, let me just conclude our proceeding tonight with a few comments. The first is to thank you again for your time and your interest this evening. We hope as well that you have found it interesting. An evening like this reveals quite a bit about our court system, but one thing it reveals is that this court hears and resolves disputes and cases that arise across our state in every community. And this case tonight, the parties have brought before us, asked us to resolve a question involving Iowa's Open Records Act and how it applies to the facts of this case. So our decision that will follow will decide this question for the parties, and in turn, it does something else, because the decision then will join the body of the law of all of our other cases that we have decided, and will then be used to help resolve similar disputes for Iowans based upon the precedents that cases established. And so it is in this way that courts operate and engage in the process of governing by using our decisions to establish order in life and to ensure and fulfill the protections of the law for all people. If you are interested in following this decision, it'll probably be a couple months before it'll be appear in a written resolution, but we know that this is an important case. It's waiting a decision, and we'll work as quickly as possible. If you're interested in following along, we do report every Thursday the cases that will be filed every Friday, and you can go on our website and read the decision when it is filed. We look forward to joining you in a reception on the second court of this building in the light court. Immediately after court, we'll come right down and be there as you're walking in. So thank you again for your time this evening. And with that, I'll ask the bailiff to adjourn court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.